DW Africa Link.
Would you rather go to jail or do a community service? Should someone who steals a loaf of bread or commits a minor offense spend months behind bars? Or could they repay society in another way? Well, Ghana's parliament has passed a new bill that would allow some offenders to perform community service instead of serving prison sentences. It makes me wonder, is Ghana simply easing pressure on prisons or actually changing how the state thinks about minor offenders? And how will it work? That's what's coming up. I am Eddie Micah Jr., and you are welcome to Africa Link, the podcast connecting you to the stories that matter.
Africa Link, every weekday here on DW.
For years, Ghana's prisons have been crowded, costly, and under pressure. Now the country is trying to rewrite the rules of punishment with a bill that says not every offender belongs behind bars. Let's dig into this with Christian Malm Hesse, a private legal practitioner. I also have our very own Eric Mawena-Egbeta, DW correspondent in Accra, Ghana. Hello, both of you. Welcome to Africa Link. Eric, tell us more. What really is in this community service bill that's been passed by Parliament?
Right, Eddie, thank you very much. And so, community service bill, as passed this year, 2026, essentially is seeking to introduce an alternative custodial sentence for certain categories of offenders, right? Generally, it is very well known that Ghana's prisons have been congested for a very long time. And there have been efforts to try and deal with the congestion situation. But as laws exist to deal with crime and to safeguard society, more and more persons continue to fall foul of the law and are ending up in prison custody. This idea has been mooted for quite a while that, look, why don't we find alternative ways to punish persons who commit lesser offenses, misdemeanors, and some other things, which by a long stretch attracts up to 3 years in prison and some others. Instead of sending those persons to prison, can we find alternatives such that we punish them, but we do not take them into prison where they joined other hardened criminals and then return worse off than they are? And so this conversation has been on for quite a while, as far back as when plea bargain agreement conversations started in that regard. There were conversations as to community service as well to serve as an alternative in terms of punishment. And so the legislation, which has undergone quite the conversation, will give judges the discretion to impose community service orders instead of imprisonment for minor offenses.
Right. Lawyer, let me come to you from the legal perspective. Is this a good deal? How is it really going to work?
Yes, I mean, it's a good deal. It's in a step in the right direction, especially as it's the biggest benefit is that it will help with the decongestion of the courts, of the prisons. That's to say about 35% of overcapacity is experienced in our prisons, and so that's one of the main benchmark achievements that would come through it. I mean, also just as my brother said early on, we're going to have hitherto where misdemeanor offenses of convicts run through custodial sentences. Now we are going to have them served through community services and under a legal framework. So a general breakdown, and if you look at the general objectives of the law, I would say I'll put it in 3 aspects. It has a primary object that it establishes the Community Service Secretariat, which is to regulate and see to how this whole community service would be orchestrated, or how persons convicted under this particular act would carry out with their community service. Then you also have the fiscal and systematic relief. Basically, it targets severe prisons dealing with overcrowding. I mean, inadequate budgetary allocations and high feeding or medical costs for prison inmates. So these persons will not go and add up to the already stressed budgets of the prison service in dealing with some of these things. And also, if you look at the policy origin of it, I mean, it was developed out of the 2014 non-custodial sentencing policy, which is backed by the UNICEF and a draft in collaboration with non-profit organizations, the sector of sentiment. They basically call them POS. So, I mean, there's an international approach to it in terms of policy, which also influenced the passing of this bill.
The point where I would want more clarity on is what the threshold would be like to decide which kind of offenses would be eligible for community services and those that require, actual going behind bars. Can you break that down a bit for us?
Yeah, so I'll take it on a three-limb approach. So the first is the 3-year rule, and that deals with the community service order, which specifically applies to offenses punishable by a maximum of 3 years or less. So that makes it a misdemeanor. So basically, the first thing is that it only touches on misdemeanor matters. Then the second one is the fine structure. It covers also offenses carrying a fine only, a fine with custodial option, or both. So definitely with misdemeanor matters where it is either the convict as have been sentenced would pass. The accused person as has been sentenced is sentenced to either a fine or both. And then the explicit exclusion rule. This one, I categorize it as it's a situation where the courts are legally barred from making a community order for any offense that is unsuitable for summary determination. So that if the courts are not to engage in what we call ultra vires, they ought not go beyond what the act is mandating them to do, such that it basically deals with, it goes back to the first point. It deals with misdemeanors, and as far as misdemeanors are concerned, is the microscope for this act to work. Anything beyond it would not.
Just to further break this down, for example, as a lay person, trying to understand what this really is. Let's say if I went out there and stole some, tomatoes, because I was hustling. I just didn't have money to get tomatoes. It's not right. So it's not right, but I still went to steal these tomatoes. Compared to someone, say, who actually broke into someone's house and, took appliances, maybe even injured or hurt people in the house. Is it automatic for me to say that the one that stole tomatoes will have the community service and the one that injured and broke into someone's house stealing all these appliances will get the jail time? Is that as simple as that, or is there more to it?
I mean, in the hierarchy of offenses, we have, so when we say first degree, it means very serious offenses. When we say second degree, they are in the middle, not too serious, not too of a petty offense as well. Then when we say misdemeanor, it deals with petty offenses. Now, the difference between the upper two and the last one is that the last one deals with summary trial. So that one, the court is not mandated to have the jury and all of those things, and then the indictable offenses would know. So that one, it is summary, and it will be determined summarily. That's why in giving out the last one, I indicated that with explicit rule that deals with the Community Service Act, the court is barred from dealing with other matters except matters that can be summarily heard. So any matter that can be summarily heard basically deals with misdemeanors, offenses that are not serious, offenses that are petty, so that the court will not concern itself in putting people who have done second degree and then first degree, like rape, armed robbery, burglary. So if you scale into somebody's house and you go and steal even a watch or a tomato, it is stealing, and stealing deals with, it comes under second degree felony. So those are serious matters. So that's how sometimes we say that how can somebody stole a goat and this, that. Now, so it is the categorization of the offense that makes it serious or not.
So it doesn't really matter what you stole, tomatoes or a car or whatever it was, that is considered a high crime. And in this case, you're saying that would not be requiring community service, but that would probably be jail time. So what crime would merit community service?
So any crime that is petty, any crime that the threshold will not be more than 3 years is considered a crime under or an offense under the community service that will be commuted by community service. An example includes traffic offenses. An example includes false publication, just like the TikToker that went viral, who incited the public. I mean, the court deemed that whatever she said affected public peace, and that she also put up false publication about the sitting president. Mind you, it is not just about the sitting president, but false publication matters not who the person is, but it is about whether or not that publication was made and whether it affected a particular person. So normally the court will look at the elements for a crime, and that is, we call it the mens rea and the actus reus. The mens rea deals with the mind, the intention, and then the actus reus deals with the circumstances. So these two coincide in order for us to get what we call a criminal offense. And when that is established by the prosecutor, then we say that the crime has been proved beyond reasonable doubt.
That's a good breakdown, ultimately, to make us understand things a bit better. But that really begs the question, Mawena, if people really understand what this would mean if eventually passed into law. I mean, is there enough education already about it? Do people know what this is about?
I think that's where a bit more in terms of work will have to go down because, like, I was hearing the conversation and the difference between stealing just a tomato and someone stealing huge sums of money, all having to suffer the same fate. That's been one of the many things people believe should be a basis for which some of the sentences can be reduced to community service. But it only suggests that a bit more in terms of education is required for the ordinary Ghanaian to appreciate and understand that an offense which is higher than the misdemeanor which we are being educated on right now would mean that you will not get community sentence. And so the onus now will lie largely on the state. Yes, the bill has been passed. We are waiting assent officially by the president on it. But it will mean a lot more persons will need education on it. And for us as media persons as well, we need to speak about it more and more. And if there's a possibility that it will go beyond, there could be possible amendments in the future to include offenses which may be classified as between serious offenses and then not too serious offenses, like the example you cited, then that will excite a bit more persons. But in its stature and current form, that may come as a bit more in terms of disappointment, or will come as a bit of a disappointment for a lot of people, because increasingly, like you've mentioned, persons argue that why is someone stealing just a small thing and they are getting to serve 10 years in jail? and they cannot be allowed to just sweep because perhaps they were hungry and that's why they went to steal food.
Right. And still with you, Mawena, I'm just wondering if the local courts and the districts, if there's enough infrastructure to implement the community service effectively, because this is something that clearly needs to be monitored. There has to be proper systems and enough people making sure that it's being implemented properly, right? Are there any concerns about that?
Well, what happens with legislation like this is that it takes some time for it to begin to, because as we speak right now, the assent is yet to come through. What I know of the judiciary, as someone who's reported from the court a few times, is that whenever some of these sweeping legislations come in terms of how it deals with sentencing and others, trainings and retrainings are organized, or some bit of education as well is provided to the judges, magistrates, and what have you, to appreciate the nuance of the legislation and in which areas they can apply it as well. And so once the asset comes through, the expectation is that we will see that like the Office of the Special Prosecutor's Bill, for instance, judges had to be taken through the process and all of that to appreciate the legislation. And so it will be same for this when it is assented to, and then they can begin implementation. For now, I cannot say that the structures exist. There won't be a requirement of a structure per se, because it will just be something judges will consider now instead of handing out prison terms. Previously, there wasn't the room for a judge to decide to look at. So the judges deliver judgment specifically on what the law says. What are the punishments? So if it is misdemeanor or a petty offense, what does the law say is the punishment? It says 3-year jail term or a fine of, say, 1,000 penalty units. Now, the law also adds that in considering punishment, you can also consider community service. And so there won't be the need for a structure per se. It will just be one of the many considerations judges will have now before they sentence an individual.
Right. I want to come back to you, lawyer. Is there any room for bias in deciding some of these cases that could lead to community services? Is the bill strong and clear enough on exactly how to decide these, or is there more work to be done?
All right. There are some few gray areas, but largely it is a well received bill, which when assented becomes law to regulate this particular area of the criminal justice system. Now, it must also be said that the law gives, or as it would become a law, there is a mandatory social inquiry test, and so this is purely discretionary, and the law encourages the judge sitting in the court to carry out this social inquiry in order. So I mean, let me be explicit a little bit on that. That before the sentencing, the judge must direct a probation officer, to conduct a formal social inquiry into the offender's specific character and any form of antecedents or case circumstances, and then also look at the mental health of the offender and see whether or not that person is in fine tune to carry out with the particular sentencing granted. And then also what is also left with this an ally. So the ally is a legislative instrument that when bills like this are passed or laws like this are passed, it becomes the secondary legislation under which operations become effective. So the law is passed, but the airline makes the law operational. And all these things that we want to see, the funding innovations and the gaps that we are seeking to fill, all these things would now work out through the airline. So the law says that there should be a rehabilitation fund. How is the rehabilitation fund going to work out? And how are we going to draw it? The law says that there should be third-party monetization source. In terms of revenue, that it becomes a core source of money for the fund.
Okay.
In order to accrue from provisions of services by convicts to third parties. And in talking about this, it will basically draw me just a minute to how the law also cautions, or it has made provisions in order to bar, and not just bar, but consequence or sanctions have also been construed in the act, so that it would prevent prison officers or probation officers or wardens from taking advantage of this community service persons for their own benefit. Because just as I mentioned,
I think that these are all very key points that you're mentioning. So while you're saying all of this, I'm just wondering if Ghana's approach is similar to any other African country that we can compare with, because of course then that would make things relatively easier, right? So are there countries that are trying to do this also? And how does Ghana's approach compare to those countries then?
Zimbabwe and Kenya are the countries that my mind can stretch to. And for Kenya, they call it the Community Service Orders Act 1998. And if for Zimbabwe, if you look at the maximum statutory sentence threshold, they have the target sentence of 12 months or less. So for Kenya, they apply is generally to offenses carrying 3 years or less, just similar to Ghana's own. And if you extend it to United Kingdom, they call it the Criminal Justice Act 2003. Theirs is open-ended, and the community orders can substitute sentences of up to 12 months, or they act as an explicit standard loan tariff. For Ghana, we have it. The orders is up to 6 months, and it's between 4 to 8 hours. Now, when you look at Zimbabwe, they have a purely flat approach to it, and they cap it at 350 hours. And then for Kenya, it's also strictly defined up to 3 years of ongoing part-time community placement.
So there's some examples out there, which means that for everything to come out smoothly in Ghana, if this eventually becomes law, which seems like that's going to be the case, then it should hopefully be smoother for Ghana to implement this. I've learned a lot, legal terms and breaking it down. So I really appreciate that, lawyer, that you've taken the time to do this. We'll keep tabs on this, obviously. After the president signs it into law, we will probably jump back on it to see what real efforts on the ground are being put in place to make this really work well. Otherwise, many thanks to you guys for helping me understand this. Christian Malm Hesse, private legal practitioner, and also Eric Mawena-Egbeta, DW correspondent in Accra, Ghana. Thanks to you both.
Get the stories that are shaping the continent here on Africa Link.
Supporters say it could ease overcrowded prisons, save taxpayers' money, and give offenders a second chance. It's an ongoing discussion on the streets of Ghana.
I believe the community service bill is most appropriate for minor offenses. And one thing I'd want to say is that it would be appropriate for minor offenses if it is applied fairly. The method of application is what would determine whether it's a good bill or not.
So I think the community service bill is a great bill in that it would help us with our capacity building, nation building, and also ridding our communities and our environment of waste. Would have cleaner cities, cleaner regions, and also making good use of our labor, instead of overcrowding our prisons, people with minor offenses get to also do something that would contribute to the nation as a whole. So I think it's a great bill.
For generations, justice has often been measured by the length of a prison sentence. But maybe there's another way. The real test is how this can move from promise to practice, from paperwork to impact, and from reform on paper to justice people can actually see and trust. Otherwise, it will just be another good idea trapped in a broken system. What do you think? Share your thoughts on Facebook at DW Africa. Listen to us on Spotify or wherever you get your podcasts. And subscribe to our DW Africa YouTube channel so you never miss an episode. This show was co-produced and edited by Isaac Kaleji. And I am Eddie Micah Jr. Thanks for listening.
DW. Made for minds.